Speaker of the session is Mozhdeh Pourmand. Mozhdeh is a qualified attorney, member of Iran Bar Association, and partner in Andisheh legal firm. She is also legal and compliance counsel of Unilever Iran. She started her career as the legal counsel in a firm in Dubai, moved to Iran BAT as in-house counsel. Mozhdeh also headed the legal and compliance department in Novo Nordisk Iran for almost over 3 years before joining Unilever. Mozhdeh was vast experience both in-house and external counsel to many multinational companies in legal and compliance issues, in particular in the areas of IP and brand protection, contracts, corporates, code of ethics, as well as exports controls in business international environment. She holds an LLM degree in international trade law. The floor is yours.
Good morning, and thank you, Irmek, for the introduction, and thanks for pronouncing my name correctly. That doesn't happen very often. I think you need to present the PDF format. Okay. So, very good morning to everyone. I think this session is is where the two boards of the corporate or M&A lawyers are meeting with the IP lawyers, and that's what it was very interesting also for me too. What I wanted here to touch upon and also build on what my colleagues said before is the importance of M&A. Here is the M&A growth. Sorry for the PDF looks like that because I made it on the Mac, then it turned out like this. So it's not very much Windows user friendly.
You should use the PowerPoint.
It doesn't show up.
Really?
In his computer, I don't know why. Anyway, but here is the value of the M&A. That is just, it has a flow and it's growing, or it shows a very big value in terms of the US $1 billion in the world. Although most of the very famous big M&As are happening in US, but what I wanted to focus is that, especially in the emerging market, it is also becoming a business necessity to go on, because many of the big multinational corporate companies are forced to move into local productions in the region of the Middle East, and sometimes the easiest way to get into the market as a market access strategy is to go through a merger or through an acquisition. So maybe not in terms of the value, but in terms of the volume, or maybe in the future business, M&A is becoming a way to have a business continuity or to have a business growth in the region of Middle East. So that's make it more important from that perspective. So going to that, I wanted to touch that as a corporate lawyers or as an M&A lawyers, when there is even a negotiation to start a deal, we have a very broad checklist together with the finance usually and the business analysis. In that list, we have everything that we can think of from the organization structure, from how the corporate is standing, I mean, who are the shareholders, I mean, what are the funds, the securities, everything. But more than 30% of the times, intellectual property is not the first thing that comes into the mind of the corporate lawyers. So we go through everything, and then usually it is missed out, but that shouldn't be the fact. So that's why that I say these two words might meet each other in that area. So when we talk, and you are the expert, so when we talk about IP covers everything that I've tried to put it in this slide, and my friends talks about it. So it covers from trade secrets, from everything that has about the domains, design, patents. So you know the details. So I'm not going through that. But what I wanted to say is that although usually the corporate lawyers or the M&A lawyers do not consider IP as the first thing, as a financial value, But I've brought some fact sheets that I wanted to share with you that actually IP is constructing a big portion of a financial value of a company. And that would make another reason that even it should come prior to the other aspects of the due diligence, when even the thought of an acquisition has come to the mind. These are some facts about the big corporates, that they are how they are adding their financial value only through the IP, even from some of the products that they're not producing themselves. They are just licensing it. But also I want to share with you some of the facts about the concept of the IP, which is missing most of the times in the companies. These are again the statistics and the fact sheets that in some of the surveys, like for example, in around 20% of the big EU companies, even when they're in an employment contract, the provision of IP and confidentiality is missed out. Or in Europe, the last statistic is that the 36% of the patents that are registered are not even used by the company. Or in more than 35% of the M&A deal, the IP is not audited, or is not audited as the first step of the M&A deal. So that's a sort of a fact sheet that helps us to know what are the risks and what is missing out between these two groups of the lawyers when they are sitting together. As my friends went through the whole IP due diligence in details, but there is a checklist usually for the IP that they need to go through. And then the reasons to go through this due diligence at the end is that to determine the deal evaluation, and it might very much affect the deal, because as the famous Volkswagen and Rolls-Royce example, if the IP is not there, even the whole structure, the whole financial, the whole contractual procedure goes smoothly and very well, but at the end, the evaluation of the deal has not been done correctly. So if it's done most of the time before any action, even this decision, then the value of the deal might be different, or even it might be reconsidered to go through that acquisition or not. But when it is evaluated, what we are usually looking into that, the IP that brings up a value to the company is a kind of an IP that should make the company to have a more stronger position and have a better competitor privileges to the other competitor in the same market. And also, it should provide a high profit margin to the company while it reduces the R&D cost. So these are the factors that needs to come to the evaluation procedure, usually with the help of it should be a team of the IP experts, the corporate lawyers, and the financial department, in order to make sure that these factors are met and the IP really adds any value to the deal. Or if IP brings a sustainable business continuity, that depends on the terms of the validity of the patent. If that is valid for a longer period, then definitely the value of the deal should be higher. As I said, it should be a team, it should be a completed teamwork. So it should be the technical experts of that sector, like the first panel that we had from pharmaceutical, the IP team, the M&A team, corporate lawyers, financial. So it's a better position that they all sit together, even if they're doing an IP due diligence and IP evaluation, so that everyone has every aspect is made sure that is covered and the good evaluation is made before the deal even is done. So we try to escape from the repetition. I think many of the parts were covered by my colleagues, but we can go through the questions.